sure that we get something straight for the record, because if there is a court proceeding about this, this will be very relevant to the trier of fact, to the judge in that matter. You said in your own words, I think, just a few moments ago in response to my inquiry, that the subpoena that you issued, that this committee issued to the Attorney General, is just the next step in a dialogue. We're here on an extraordinary contempt citation. This is not a game. Your subpoena is issued to the Attorney General of the United States of America, and it reads in its first line, "You are hereby commanded." That is not an invitation to a dialogue unless we're going to construe it that way.
Hold on right there. Democrats spent the entire day yelling constitutional crisis like the sky was falling, while pushing a subpoena that would force the Attorney General to violate federal law. And then the second Republicans corner them with the actual wording, "You are hereby commanded." Suddenly it's, oh no, it's just part of a dialogue. A dialogue? Since when does a legal command sound like, "Hey buddy, let's talk it out"? That's not oversight, that's political theater with a law degree. Republicans just ripped the curtain down and showed everyone the script. If you're tired of the drama and ready for facts, hit like, subscribe, and stay right here. Let's watch the full clip before I give you the full breakdown.
Thank you, Mr. Chairman. We have heard some extraordinary claims this morning. I've been taking notes as my colleagues have commented on all of this. Congresswoman Sheila Jackson-Lee said the executive branch is, quote, taking a wrecking ball to the Constitution. And Mr. Chairman, you said that the DOJ doesn't recognize Congress as a co-equal branch of government or acknowledge our oversight responsibility. Mr. Cohen said we're trampling upon Article 1. Anyone who looks at these facts objectively knows the truth is exactly the opposite. The Attorney General and the DOJ are objecting to this charade based upon the rule of law. They are trying to protect the integrity of our institutions. And Mr. Chairman, you said that the preliminary protective assertion of executive privilege this morning was a last-minute outburst. It's exactly the opposite of that. In fact, the letter that the DOJ sent to you this morning says, and I quote, "Regrettably, you, Mr. Chairman, have made this assertion necessary by your insistence upon scheduling a premature contempt vote." The letter goes on to say, "You've terminated our ongoing negotiations and abandoned the accommodation process. And as we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law, court rules, and court orders, and without threatening the independence of the Department of Justice's prosecutorial functions." That's a quoting from the letter. The facts matter. The letter that the Attorney General sent to the President this morning that accompanies all this says, quote, "The committee demands all of the special counsel's investigative files, which consist of," everybody listen, consist of millions of pages of classified and unclassified documents bearing upon more than 24 criminal cases and investigations, many of which are ongoing. These materials include law enforcement information, information about sensitive intelligence sources and methods, and grand jury information that the Department is prohibited from disclosing by law. That's the letter the Attorney General sent to the President explaining all this. Look, we're attorneys on here. Most of us are attorneys on this committee. What does the law say? The courts have repeatedly affirmed the rules on all this. April 5th, just last month, the U.S. Court of Appeals for the D.C. Circuit ruled in McKeever versus Barr. The district courts may disclose grand jury materials only where they have positive authority to do so, particularly through the exceptions to grand jury secrecy listed in Rule 6E. The Court of Appeals explained the vital interests, they said, that the rule of grand jury secrecy seeks to protect, including preserving the willingness and candor of witnesses called before the grand jury, not alerting the target of investigation who might otherwise flee or interfere with the grand jury, and preserving the rights of a suspect who might later be exonerated. These are critically important principles and traditions for us to uphold, and it is, again, the law. The chairman can file suit for access to the 6E material, but instead he blasts the Attorney General for not joining him in doing so. Why hasn't the chairman taken that step? I think I know why. Perhaps because he knows that his rationale for demanding the unredacted report is wholly insufficient. Look, this bears repeating. The chairman claims he needs the full unredacted report as part of the March 4th, 2019 investigation into the 81 individuals and organizations related in some way to President Trump. But let's make a couple of facts clear. The investigation, we don't even know if it's still ongoing. We haven't heard much about it lately. The lack of activity surrounding the investigations makes clear the majority here is not interested in pursuing this for any legitimate legislative purpose. This is about scoring political points. The chairman's public comments surrounding his need for the full report are almost exclusively focused on obstruction, but another important fact here, 99.9% of the obstruction volume is available right now for the chairman to view, but he hasn't done that. Only 6 lines and over 182 pages is redacted in the obstruction volume. This is not about seeking the truth, as we've heard this morning. It's about raw partisan politics. Our Democrat colleagues have weaponized our critical oversight responsibilities. And moving today to hold the AG in contempt is not only premature, unprecedented, and unwarranted, frankly, it is shameful. We believe the American people deserve better. I hope that they'll review the facts. I hope they'll look at all this correspondence. I hope they'll get beyond all this cloud of partisan politics and understand why we are taking the stand today that we are. I yield back. Chairman, I have a point of clarification. It's a bit technical, but I do believe it's very important for the proceedings today. Before we recessed, the committee voted unanimously to adopt an amendment by Mr. Gates that provided that nothing in the resolution shall require the Attorney General to break the law in complying with the subpoena. And a number of Democrats, including you, assured the committee your intent was not to force the Attorney General to disclose 6E material, which would, of course, be in violation of the law.
Without a court order.
Without a court order. So on April 3rd, this is the question, Mr. Buck offered an amendment to specifically exclude 6E material from the subpoena. And I have the amendment right here, and I'd ask unanimous consent to include that in the record.
Without objection.
Every Democrat voted against that amendment, and I have the vote tally right here as well, and I'd ask to include that in the record as well.
Without objection.
The amendment failed by a party line vote, 16 Republican yeas and 24 Democrat nays. This morning's vote changes nothing about the subpoena and the demands that are put on the Attorney General. The subpoena, as it stands today, requires the Attorney General to break the law to be fully compliant. If you look at it on its face, that's beyond dispute. I know that, and you know that, and yet you are nonetheless rushing to hold him in contempt. So despite your intent that the subpoena not require 6E material without a court order, that's what the subpoena you issued actually demands, if you read it on its face. You and every single Democrat member on this dais voted for that, and that's the danger that we're talking about today of moving forward so quickly on these things. So here's the question. I ask my good friends and colleagues on the other side, how do you explain today's sudden change of heart? Is it true that it is not your intent to force the AG to break the law by forcing him with your subpoena to disclose 6E material? And if that is your intent, that proves what every Republican on this dais has been saying all day. If it's not, then the subpoena you've issued is dangerously overbroad, and the question is, are you going to reissue a new subpoena? It's a change of heart that I think bears some clarification. I'll yield.
No, we're not going to issue a new subpoena. We have no intention and never had any intention of trying to force the Attorney General or anyone else to give us 6E material without going to court. We did want to, and we still do, want to follow the procedure that has been done in every similar case in the past of going to court, which we will do, to ask for 6E material and having the Attorney General go with us. The reason that was in the subpoena was to increase our clout in court in getting the 6E material, hopefully with the Attorney General's support, but in no way meant to force him to give that support.
Mr. Chairman, reclaim my time. The way I understand it, the Attorney General would be required to go to court to avoid the way the subpoena is written right now. Well, he would be required to go to court.
Yield.
I will yield. Yes, sir.
The subpoena is written as the beginning of a dialogue process, as the beginning of a process to talk to the Attorney General and to the Department of Justice, and ultimately to go to court. But it's designed to be the foundation of a dialogue and is not designed to force our hand in what we insist on in court.
Mr. Chairman, the beginning of a dialogue, let me yield to Mr. Buck, if I may. Mr. Chairman.
Let me just point out.
Well, wait, this is my time, Mr.
We have accepted the amendment today. We've stated the intent. I think that should take care of the matter. Go ahead.
This is a contempt proceeding. Let me yield to Mr. Buck.
Mr. Chairman, I've issued many subpoenas or requested the court to issue many subpoenas on behalf of prosecutors' offices that I've worked in. I've never considered it the beginning of a dialogue. I've considered it a command by the court to produce documents. We are now in a contempt proceeding, And I'm not sure whether you consider this the middle of a dialogue or the mid-beginning of a dialogue, but I consider this a pretty serious matter, as is issuing a subpoena from the Judiciary Committee. If it was a dialogue that you were interested in, and I understand that it's your position that you had attempted a dialogue for 2 months before the Department of Justice came to the table, but if it's a dialogue you're interested in, I believe there are other methods of going about that than a command from Congress to the administration to supply documents. And this is a far, far cry from anything other than one of the most serious matters that we will handle in the Judiciary Committee in the year 2019. So I would ask, and I thank the gentleman for yielding to me, but I would ask you to clarify exactly what we're doing here in contempt, if this is part of a dialogue with the Attorney General.
And Mr. Chairman, just reclaiming my 6 seconds that I have left, in the letter this morning from the Department of Justice to you, he says, you've terminated our ongoing negotiations and abandoned the accommodation process. That's a dialogue. Why did you do this, and why are we here if this is part of the dialogue?
We didn't terminate. They did by refusing to make any offer in good faith. The gentlelady from Florida is recognized. For what purpose does the gentlelady from Florida seek recognition?
Mr. Chairman, I just want to make sure that we get something straight for the record, because if there is a court proceeding about this, this will be very relevant to the trier of fact, to the judge in that matter. You said in your own words, I think, just a few moments ago in response to my inquiry, that the subpoena that you issued, that this committee issued to the Attorney General, is just the next step in a dialogue. We're here on an extraordinary contempt citation. This is not a game. Your subpoena is issued to the Attorney General of the United States of America, and it reads in its first line, you are hereby commanded. That is not an invitation to a dialogue unless we're going to construe it that way. And if that is the view of the chair, we need to make it crystal clear for the record right now so we can dispense of the court hearing that many of us anticipate to come out of this. This record will make that court hearing moot and unnecessary. This is a dialogue and not intended by the sender of the subpoena to be an actual subpoena, apparently. Look, the authority that we have in the Congress to issue subpoenas is a heavy one. We should not weaponize this. We can't be using this stuff for political purposes, and that's what's happening in this committee right now. Many of the legal rights usually associated with a judicial subpoena don't apply to a congressional subpoena. We have a huge weight of authority, and I just feel like it's being abused here. And I think the admission that you made just a few moments ago is extraordinary. It makes much of what we've done here today a total waste of the American taxpayers' time.
Recognized.
Thank you, Mr. Chairman. I just want to make a simple point. We have been here a long day. There's been some extraordinary admissions, I would submit, by the chair and those who have issued the subpoena. But I just want to quote one more time one line from the letter that the Department of Justice Assistant Attorney General Stephen Boyd sent to you this morning. It begins, we are disappointed that you have rejected the Department of Justice request to delay the vote of the committee on this contempt filing this morning. You've terminated our ongoing negotiations and abandoned the accommodation process, and this is the important phrase. As we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law. Some of our Democrat colleagues have conceded, I think, over the course of the last hour, that this 6E material, that there are ways to get around this, that in its current form and on its face, maybe the subpoena says one thing, but it really means another, and the chairman says, oh, this is just part of an ongoing dialogue. This entire charade today was premature and unwarranted. Our Democrat colleagues have effectively acknowledged that on the record. I think this amendment is one we should support because I think it is not a legal opinion, as Mr. Cicilline said. This is a statement of facts. The facts, the important facts that have transpired over the last couple of weeks in this good faith negotiation by an Attorney General that has been completely transparent and who is limited only by the written rule of law. He is trying to comply with that. Mr. Nagu said a few moments ago that, look, there are ways to comply, you can get around this and work with the subpoena. That's exactly what the Attorney General has been trying to negotiate in good faith. And yet we jumped the gun, we came in here, we've wasted an entire day when all these important issues are pending before the country, tying up the hands and the time of how many members are on this committee? 40 members of Congress are tied up into this. And it's only, as the chairman says at the end of the day, I just repeat it because it's so extraordinary that he admitted this in this rare moment of candor. Hey, this is really just the next step in an ongoing dialogue. We could have continued that dialogue without this charade. I'll yield back.
Now that you've seen it all, let's be honest about what just happened. The Republican members dismantled this stunt piece by piece. Democrats spent hours accusing the DOJ of shredding the Constitution, trampling Article 1, and disrespecting Congress. Meanwhile, they were the ones demanding materials the Attorney General is legally prohibited from handing over. Not politically prohibited. Not inconveniently prohibited. Legally prohibited. The DOJ letter spelled it out in plain English. Millions of pages, classified material, intelligence sources, ongoing investigations, grand jury secrecy under Rule 6E. Courts have been crystal clear on this. You don't just dump grand jury material because Congress feels impatient. There's a legal process. You go to court. Period. And then came the moment that flipped the whole table. After pushing a contempt vote, after all the outrage and chest thumping, Democrats casually admitted the subpoena was really just the next step in a dialogue. A dialogue? Since when is a subpoena a polite suggestion? Since when is a contempt proceeding a friendly coffee meeting? That wasn't oversight, that was political cosplay. Republicans called it out exactly for what it was: premature, partisan, and reckless. If this were truly about transparency, they could have continued negotiations. Instead, they rushed to hold the Attorney General in contempt while simultaneously admitting they never intended to enforce the subpoena as written. That's not serious governance. That's headline chasing. And here's the kicker. They voted down an amendment that would have explicitly excluded the illegal 6E material, then pretended they never meant to demand it. You can't write a subpoena that says, "You are hereby commanded," reject language that narrows it, and then claim it's just symbolic. That's not how law works. That's not how subpoenas work. Every attorney in that room knew it. The Republicans stood on the rule of law. Democrats stood on political theatrics. One side defended grand jury secrecy, prosecutorial independence, and court precedent. The other side tried to weaponize oversight for a TV moment and got exposed on the record. This wasn't a constitutional crisis. It was a credibility crisis, and Republicans made sure everyone watching saw it.